Good afternoon.
My name is Lawrence Keane. Mr. Finley is unavailable. He's testifying on another matter. I'm the Senior Vice President for Government and Public Affairs and General Counsel for the National Shooting Sports Foundation, testifying in opposition to this bill, chiefly because it would violate federal supremacy laws. Would be unconstitutional because the Protection of Lawful Commerce and Arms Act would not permit a lawsuit against manufacturers, distributors, and retailers for the criminal misuse of lawfully sold non-defective firearms. Among the problems with the bill is that it would regulate commerce through litigation and the exposure of lawsuits taking place wholly outside of the state of Washington. A manufacturer selling to a distributor, selling to a retailer who lawfully sells a firearm to an individual after a background check, that firearm ends up in Washington being misused, would be exposed to liability unless that retailer, et cetera, adhered to the desires or wishes of the state of Washington. And that's not permitted. In fact, the Ninth Circuit has already held that a statutory or codification of a public nuisance claim did not fit within the so-called predicate exception within the Protection of Lawful Commerce and Arms Act. The predicate exception is limited to knowing violations like provisions of the Gun Control Act or analogous state laws. And the statute gives specific examples of those sorts of laws. And a general public nuisance claim that can be violated not because of a knowing violation does not fit within the predicate exception. It is also unduly vague because it would impose liability if you do not take certain measures, including but not limited to, and it doesn't tell you what those other things are. So you can't knowingly violate some other provision or practice that the state has not articulated. If the state wants to enact, for example, a requirement that dealers under state law conduct an inventory, they're perfectly free to do that. And a knowing violation of that statute would not be protected by or barred by the Protection of Lawful Commerce and Arms Act. So I believe this statute would be unconstitutional and would be subject to litigation challenges by the industry. Thank you for your time.